time frame?
It depends on the particular circumstances, but one should seek something that is not going to scare off the other party, i.e. 25 years or forever. You want enough time to figure out the lay of the land, test the market, file for a patent or other type of protection. Typically, 2 to 5 years from the date of disclosure would make some sense.
Okay. Good info. So tell us now, when you do have some kind of opportunity where you're licensing or somebody buys out your patent, you always continue to remain the owner or the inventor, but you can assign your rights to whoever it is that you license or sell your idea to, right?
That is correct. In fact, there's so much of that activity that the Patent and Trademark Office has special servers to handle only assignments of patents.
So we've heard about different types of intellectual property here. So I come up with this idea, Marty, and I think it's going to be the greatest thing, it's going to be the next Angry Bird, Flappy Bird, all these different apps that are out there. And it's simple enough to do a search on the different platforms. When you're coming up with an idea, I tell people to go on Google to do a simple search, and Yahoo and Bing, and try some of the different searches. And when you're searching, search to find it. Don't search to not find it. This way you know that you're able to move forward and you're not wasting your time and, work on your next idea. But on the mobile app side, when you're doing a search, can you give us just before a preliminary idea of how to look for it before we start getting into the patent files?
Certainly, what you've described using the mass market search engines is a very, very good place to start, if for no other reason than the price is right, i.e. free. But you might also start with a trademark search or a patent search in the public databases maintained at the Patent and Trademark Office. There are commercial companies that do this, but these databases are open to anyone, and you can search on whatever keywords seem to be pertinent under the circumstances to at least get a preliminary idea of whether someone has already gotten to where you want to go and whether it makes sense to take the next step, engage a commercial search firm, engage an attorney. Certainly there are public databases available at uspto.gov, and they're an excellent place to start.
Okay, so
not finish, but start.
Absolutely. When you go to uspto.gov, you go to there's a trademark search, there's a patent search, and what you want to do is you want to keep your term, describing the term, especially in the patent search, kind of generic. And when you find something, take a look initially at the prior art, and you could see what may look similar, what may not look similar. Keep a log of that, and when you do have different things that you find, that's when you can bring it to an attorney or an agent and have them give you an opinion if it's something that you'd be able to move forward with or that you may be infringing on somebody else's patent protection or trademark protection. Or it may be something that has been in the market for over 20 years and it already exists and it's public domain. Or it may be a combination of two things that are already out there and you may be infringing on them, or they may be public domain. Does that sound right, Marty?
Yes, it does. Also, your point about a market overview is an excellent one. There may be something out there that's been patented, but it may not have much commercial value. Even though a patent is technically a monopoly, it's not a license to print money, and you need to see if someone else has tried this and how they're doing. If they're not doing particularly well, the legal issues are irrelevant. There's no use wasting time and money pursuing what appears to be a dry hole in the marketplace.
Okay. And then just like what we always say about the Snuggie, the Snuggie is already public domain. Well, I'm sorry, the blanket with sleeves is already public domain, and somebody came up with a great name for it called the Snuggie, and they trademarked the name. but it doesn't mean that other people can have different names for the same product and be able to get trademark protection and be able to sell it. So that's why you see many different versions of the Snuggie out there, and they have every right to do it.
Evidently, that is correct. I can't say I've researched that particular issue, but I'm aware there are different versions of that product, and I'm not aware of litigation.
Okay. So, Marty, when somebody comes to me with a mobile app that they feel very strongly about, they're excited and they're looking to bring it to market and get it out there on the different mobile platforms. And generally, when we're talking about mobile platforms, you're talking about people coming up with an idea for an app that's being used on your cell phone, on tablets, different things that people can download these apps on. So they come up with the idea, and I typically tell them there's 3 platforms. There's the Apple platform, there's the Android, and there's the BlackBerry. And I tell them to go on to each one of them and do a search within the app world of them and see what they find and see if their idea is already out there or if theirs is going to be different. And granted, there are many apps out there that are very similar. So you start to kind of get warped in figuring out what you can protect and how you can protect it. And that's why I'm happy that you're on the show to help us answer these questions. So, Marty, how do we protect? First off, you mentioned with going through the patent searches and also with trademark search, but what do we do when we're coming up with this app? I mean, give us some guidance of what to do first and second and third and so on.
Well, I think the first prong of the response is to define the we. Is it just an individual inventor, or is it a company that has outside contractors and internal employees? If you have other parties involved, you want to put in place non-disclosure and assignment agreements with those parties so there's no dispute about who actually owns whatever work product is developed.
Okay. So we're going on the USPTO.gov, or we may just go to the app itself and see the developer of the app or the company of the app and do some research on them. But when we're doing a patent search, we're going to find that apps are patented?
Yes, some apps are patented. I can't say that any app is automatically entitled to a patent. There's all sorts of detailed statutory and common law criteria that enter into that analysis, but I can say that a good example of this dynamic at work was presented in the last week or so. Walgreens obtained in January a patent for a mobile app prescription refill technique, and within a couple of weeks after obtaining that patent, they brought an infringement action against other major competitors in their space, I believe CVS and 1 or 2 others. So clearly some mobile apps are entitled to patent protection. Whether those patents will be sustained once they're tested in the PTO and probably in court, I don't know, but clearly patents have been granted for mobile apps.
Okay, so I come up with this app, and I do a quick search in the different worlds of apps, you know, the BlackBerry and Android and Apple, and I don't see it out there. And then what I do is I call up I try to, I do a quick search and everything else. I can hire a patent attorney or agent or a company to do a patent search for me on the particular app, the way the process works. But then I hire a programmer that does apps and writes apps, and I tell them to write it for me. How do I protect that? Number one, when I'm presenting it to somebody to write for me, I assume that having a patent protection of a provisional patent, or having once the code is, or having a non-disclosure in place would be the first steps of hiring a programmer, or possibly even a work-for-hire type of contract. I want to keep this simple, Marty, for the inventors listening, because they hear so many different things, and what happens is they get discouraged. And we want to help them to move forward on protecting their intellectual property. Now, I know that they could go this route. The other thing they could do is just take their idea and go to a company like the ones that made Angry Bird and potentially license their idea and see if they can help develop it, and then you would collect a royalty if it's something truly unique or they like it. But then again, they don't really have any intellectual property, so you want to make sure that you're protected in some way when you're presenting. So there's all these different questions that I've been posed with, Marty, for the last several years on these apps, and that's why hopefully you can help us, and it sounds like you can be able to answer these questions.
Certainly, I would start the process with a very simple agreement in which the party receiving the disclosure acknowledges the ownership of the idea and agrees not to exploit it themselves or pass it on. You're typically talking about a 1 or 2 page agreement of that nature. If nothing else, it's going to bolster your credibility when you go to a third party. Whatever it does for your credibility, it's absolutely essential to have something in place at that particular stage. And it's a situation where, while practitioners discuss in good faith the exact content that's appropriate for that agreement, clearly something is far better than nothing. Get something on paper with anyone with whom you are dealing, whether it's a consulting programmer, an internal employee, a proposed manufacturer, or anyone else. Get something on paper at that stage.
Okay. So that leads us to now getting the help or resource to work with now to keep moving it forward. So now we hire a programmer. They start working on the coding for us. And how do we protect that?
Once you've got something on paper in which the programmer agrees that they relinquish all IP rights to you in return for whatever you've committed to pay them, I'm not sure there's a whole lot to be done. Certainly you should maintain the secrecy of whatever work product is being generated so you can perfect your case for trade secret protection, even if you never get a patent. At that stage, though, apart from maintaining secrecy, I think a wait-and-see approach makes some sense. Let's see if they come up with useful code, and certainly you want to make some reasonably discreet inquiries in the marketplace as to whether the ultimate work product, or end product, I should say, is likely to be commercially viable. But until you've actually got something that's functional, I'm not sure there's much else to do. You might pursue trademark protection depending on how far you are away from the market. You may pursue trademark protection based on a so-called intent to use approach, where if you feel you're relatively close to taking something to market, you could apply for a trademark based on your intention in that regard.
Okay, so you mentioned a few things, and I always like to get a little bit deeper for the inventor to understand what they need to do. So the trademark, I would assume that all the coding and everything else and the way it looks, the app and how it functions is all one thing. But you're relating a trademark to the name. So I built this whole thing, and now I want to come up with a great name to protect it as an asset to the coding that I just had done, right?
Well, a name and or a logo.
Okay, so a name
you could
and
trademark one or both.
Okay, so that's on the trademark side. I want to just kind of clear that up. Then I have the coding. So the coding, I have some options. I'm going to am I going to file some kind of intellectual property of a patent pending on the coding, or is it the utility or the functionality of this app, or is it a copyright?
Or is it all of the above?
Or is it all of the above? And when you're saying trade secret, is trade secret something that I have to file with the patent office?
No. It's the opposite. A trade secret arises from the secrecy and the economic value of the underlying